from the complexities of geopolitics to the complexities of the law here in this country. Let's shift focus now to one of the country's most enduring and legally complex cases, the long-running Zuma Thales corruption matter. At the KwaZulu-Natal Provincial Division of the High Court in Pietermaritzburg, all eyes will be on Judge Nkosinathi Cili, who is expected to deliver a crucial ruling. That ruling will be on the question of whether former President Jacob Zuma and his co-accused, the French arms company Thales, will be granted leave to appeal his earlier decision dismissing their application for acquittal. This application strikes at the heart of criminal procedure, prosecutorial accountability, and the balance between an accused's rights and the interests of justice. Let's unpack all of that with the legal significance of it all with Karen Mon, who joins me now, senior legal journalist at News 24. Karen, good to see you as always. Let me invoke a colloquialism, Karen, made popular on social media. When someone does something that sort of puzzles you and you really, really don't understand it, you say, which one is this one now? Which one is this one?
I think your introduction was perfect, because essentially what this case is about is not just Jacob Zuma and Thales attempting to appeal against this ruling that dismissed their application for acquittals based on so-called unreasonable delays in their trial, which of course the state have very much blamed Jacob Zuma and to some degree Thales for. But it's more importantly to us about the state's counter-application, where they are saying, regardless of Jacob Zuma's and Thales' attempts to appeal this decision, we do not believe that their trial should be stayed. In other words, whatever appeals they mount, their trials must proceed. And that decision that Chile makes will have an absolutely seismic implication for the progress of this case going forward.
So is it about the counter-argument then, about this idea of abuse of process, that the judge should now stamp his authority and say, yes, you may appeal whatever appeals you want to make about the decisions I've made thus far, but now we will not allow ourselves to be stymied and held by this process. We will proceed.
Yes, and I think what was fascinating that Wim Trengrove, who was the advocate who was arguing for the NPA, actually said that the state should have brought this application far sooner than it did. But of course, this application is being brought after multiple courts, including the SCA, the full bench of the Pietermaritzburg High Court, found that Jacob Zuma's attempt to privately prosecute Billy Downer and myself for alleged violations of the NPA Act was the ultimate manifestation of the so-called Stalingrad litigation strategy, which Zuma had employed, the court said, to avoid his trial. And what the state has now done is that they have utilized those judgments to say, the courts have made it clear that the Stalingrad strategy is being pursued at extraordinary lengths to the extent of trying to imprison your prosecutor on a completely fallacious basis. That the trial court now needs to say so far and no further. And you know, Trengrove in his argument said this isn't just about Jacob Zuma, that this is ultimately about every single well-resourced litigant, every single well-resourced accused who is able, through futile and frivolous legal applications, to delay their trials in a way that enables them to evade accountability in the court system in a way that ordinary South Africans simply aren't able to do because they don't have the resources.
Remind us, Karen, what were the factors that were put on the table by each side? My understanding is that this application for leave to appeal the earlier decision to not acquit was initially brought by Thales for a change, as opposed to the others being brought by Mr. Zuma. And he later then joined in that application. What arguments were put on the table?
Well, essentially what happened was the Thales had previously brought an application for a permanent stay of prosecution based on this argument of unreasonable delay. And they said, look, we don't believe that we have the ability to defend ourselves because of the years that elapsed. You know, we don't feel that we have fair trial rights. And the court dismissed that and said, you have failed to show any genuine prejudice as a result of this delay. They then came back to the court and said, actually, two of our pivotal potential defense witnesses, Pierre Morneau and Elaine Tetard, have both died. And as a result, we are not in a position to be able to defend ourselves against this charge that we essentially bribed Jacob Zuma with 500,000 Rand a year, facilitated through his financial advisor, Shabir Sheikh, in order to protect us from a potentially damaging inquiry into the multi-billion Rand arms deal. And as a consequence, we believe we have a real basis to say we are not able to defend ourselves. And the court has said, as so many courts have said in the past, that is fine, but you can make that argument in your trial. You don't need to go outside of a trial process in a civil context to attempt to make that argument. If you are unable to defend yourself, if you are unable to access witnesses, of course, the state pointing out that Shabir Sheikh himself could be a potential witness should Thales choose to call him, then you can make that argument in the trial. But this idea that you can circumvent a trial process by launching civil proceedings simply cannot stand. And it is a violation of the state's right ultimately to test this evidence in a forum, in public, despite the delays that have elapsed.
So lastly then, Karen, and I started by saying which one is this one. In a way, I was trying to capture the complexity of it all, the number of applications that have been part of this matter, how it has tested and actually triumphed in as far as staying power is concerned, certainly in my case, because I was meant to be a part of covering that case until, you know, my staying power just wasn't enough to wait for the day when actually the first win. Kudos to you for sticking it out. So in terms of just readiness, whichever way it goes, around this argument of unreasonable delays, possible abuse of process, what's the sense of readiness, at least on the part of the state, to call their first witness and the subsequent witness should it go their way?
The state has said for several years now to us that they have been trial ready for quite some time. And they have vocalized their readiness. I think the first witness was going to be Patricia de Lille, who, of course, at that time was a politician who was raising serious concerns about the arms deal in Parliament and is expected to be the state's first witness when they start this trial. We, of course, know that Johan van der Walt, who was the forensic auditor who did an incredibly important forensic investigation into Jacob Zuma's financial affairs and the allegations of corruption and bribery against him in relation to his relationship with Sheikh, and of course, in relation to this so-called Thales bribe, that he, of course, passed away. He's a number of witnesses have passed away, including Sue Delika, of course, was the secretary who was going to testify about the so-called encrypted facts. She has also passed away. Yeah. But the state has said, look, we have other witnesses. We have another forensic auditor who can come and talk to that report. We are ready to run this trial. And as representatives of the public, we have to fight for the public's right to see this matter ventilated in a way that ensures that justice is done and seen to be done.
All right, Karen, all the best to you. Continue to hold fort. Mina, I couldn't. At some point, I ran out of steam. Karen Mon is senior legal journalist at News 24. We've been in the trenches for many, many years, and this case is yet to get to a point where the first witness is called.